over the last 5 decades seemed to be enough to prove causation in a lead case up until this Gaines decision. And so the Gaines decision really requires some more in-depth analysis to see what they mean by the dose-response relationship and truly understand what it means. So they rely on this case called Watts v. Radiator Specialty Company. And this is a benzene case where the plaintiff alleged that he was exposed to benzene through his occupational use, and that he had developed a form of non-Hodgkin's lymphoma as well as some other blood disorders. Importantly, the defendants did not challenge the methodology that was used. That is, the plaintiff's expert compiled 19 published studies. And so Watts said that even though the case study method is accepted, it's the trial court's role to evaluate the relevancy of each of the epidemiological studies that expert relies upon. And that it's as part of the gatekeeping role that the trial court should use its learned judgment in determining which epidemiological studies are on point, and to some degree, interpreting the results and the conclusions. What this means is that you can have a body of literature on a particular subject. A court can decide that the experts, first of all, the court concluded here that epidemiology needed to show causation, which anyone who's ever done an epidemiological deposition knows. Any person who does these studies will say that they don't show causation, they show associations. And so here Gaines talks about the distinction between plaintiff studies. And again, in Gaines, there were some that showed a relationship, but the Supreme Court found that they weren't statistically strong enough to show causation, and that even the ones that were counteracted by some others, and therefore, in its view of the 18 articles, the Mississippi Supreme Court found that it could disregard the opinions of the expert, the training, the experience, the knowledge, the other things that make up the 702 standard. Ignoring that whole piece and just focusing itself on the epidemiological work, the court decided to kick out the expert testimony. Now in Gaines, how this works is Dr. Rosen and Dr. Litsky, who are very involved in lead litigation, and I'm sure many of you in this room have worked with or against Drs. Litsky and Rosen. Here they the Supreme Court attacks the premise that a neuropsychologist can find deficits and that a treating physician, an expert physician like Dr. John Rosen, is capable of taking and synthesizing the material and the records and saying, we don't have an idiopathic, there are no other known causes. This doesn't appear to be idiopathic, meaning no known cause. And controlling for confounders, I think that this lead plays a substantial contributing role. The court seems to suggest that that's not a proper means of doing things. Now, taking the Gaines case and the language from the Gaines case, it seems to say that unless you have a kid with a 30 microgram per deciliter blood lead level, you can't downward draw and make assumptions based upon that 30. You can't take the literature and back calculate what a loss might have been. And that's a particularly concerning point, because it's very seldom that you'll come across a piece of science, piece of literature that addresses your kids' lead levels right on and addresses their lead levels right on. So this case is part of a greater trend in nationwide on these epidemiological studies and the need to correlate it for proof of causation. There was a case that came out this morning called Moeller versus Garlock It's an asbestos case that came out of the Sixth Circuit. I'd encourage everyone to read it. It literally, I think, was published, and I got emailed it about an hour ago. And it addresses this point in the asbestos context. So the concerns going forward are that you're going to there's a heightened standard, certainly in Mississippi, to show that there's epidemiological studies that mirror your plaintiff's case. This work ignores the no-threshold model that has been accepted and adopted over and over again by the CDC, the American Academy of Pediatrics. And as I said, this is part of a growing trend. There's another case before the Pennsylvania Supreme Court that's due for briefing.